All right. Can everyone see my screen?
Yes.
Okay. So we have, all right. Well, hi everyone. Thank you for joining our January California Brokers Business Accelerator on new laws and regulations for 2019, hosted by our Northern California broker, Steve Rowe, but also featuring a panel of our brokers, San Diego broker Tom Bullock, LA broker Omar Hellman, and today, I hope everyone had a good holiday season. Referrals are the best way that you guys can give us, the best gift that you guys could give us. And because of that, we want to give you gifts as well. To kick off 2019, for every agent you refer us, you will receive an Allison James branded journal. Even if the agent you refer doesn't join us, you'll still receive this special gift from us. To refer an agent to us, please go to Allison James University and click on the Referrals tab. From there, you will find a form that you can fill out with the agent's information. Allison James announced that we now have an in-house TC, transaction coordinator company. It's called Sharp TC. Our in-house transaction coordinators are licensed, knowledgeable, and experienced. You can have your first transaction done with Sharp TC for just $99. To learn more, please visit sharptc.com, where you will be able to be taken to a page where you can fill out a form to learn more. Or you can get your first transaction started right away. Go ahead and visit the page and fill out the form today. For $99, you can't go wrong. I'll pass it over to our California brokers, starting with Steve Rowe. Good morning, Steve.
Good morning, everybody. Happy New Year.
Happy New Year.
Let me know when you're ready for me to share my screen.
All right, we are ready.
Okay, am I live?
You are right, live.
All right, well, good morning, everybody, and Happy New Year to you. I'm looking forward to a fresh new year, but I thought it was important and timely, obviously. We're just January 2nd to look at new laws that affect real estate for 2019. We want to make sure that we're aware of these things, that we're keeping track, and we're able to provide the information to our clients, that they need for some of these things. And just a little bit of a background, obviously to justify their existence, the legislature is writing laws constantly. So I don't know how many, hundreds or thousands of laws were written over this last year, that some went into effect, some didn't. CAR Legal does a great job of narrowing down the list of laws and tracking the laws that affect real estate. But obviously not every one of these things is going to affect your particular real estate business. And so I've gone and narrowed it down even a little further and tried to focus on the areas that may have an effect on your business or on your clients, right? And so you can see on the screen here, there's new laws regarding building permits. There's a expansion of the civil liability laws that I need you to be aware of and be careful with. There's new employment laws. There's some of you, have businesses that are large enough where you're actually hiring employees and assistants, and you want to be sure of being aware of some of those laws. Most of us have home inspections. There's been a small change in the law regarding home inspections. There's been some new licensing and form laws, the real estate cleanup laws and regulations. If you tuned in before with my YouTube video on the new forms, you'll have seen some of that, but we'll cover a little bit of that today as well. Some expanded laws regarding clients with distress sales, insurance laws, new expansion of the protections for clients regarding PACE liens. So there's a large number of them. I'm not covering absolutely everything, and I'll show you at the end of this webinar a resource where you can go and, if you need some extra help getting sleep at night, There's some good reading on the CAR legal website. But this is where we're heading, and I'm just going to take a handful of these and give you a little bit of an idea as to what's changed, what's new, how does it affect you for 2019. First of all, there's been a couple of changes in laws regarding building permits. And how does this affect us? Well, sometimes we have clients that are buying vacant land. Sometimes we have clients who are buying homes with the intention of doing additions onto those homes. And so a couple of these changes that are going to have an effect on them. In the past, building permits have only been valid for 180 days. And so what happens is if somebody takes out a building permit and they don't actually commence construction on that permit within the 180 days, it expires. And if there's been any law changes or code changes during that time, they've got to start their process over and redo their plans to meet the new codes. So in order to encourage more building and make it a little bit less of a disturbance on consumers, the law now says they're going to have 12 months to start that construction without being affected by changes in codes and laws. And they can apply for extensions beyond that for 6 months at a time. So a little less restrictive there. And so your clients have more time to get their timing together, get their financing together and such. There's another one that affects, especially if you're in some of the areas, rural areas where buildings tend to pop up without permits or additions get done without permits. And that's always been a little bit of a difficulty and issue. And trying to get a retroactive building permit on some of these things has always been difficult. So the law was changed a little bit that instructs building departments to adopt new standards. And the standards involve the building officials have to establish when was the structure originally built. And in applying for a retroactive building permit, they can base that permit on the codes that were in place at the time it was built. So if they determine a structure was built, or maybe an add-on to the house was done in 1980 without permits, the building officials are now authorized to use 1980 building codes in evaluating that property to allow it to be permitted and moving on. So that's going to make a difference, going to make it a little bit easier, and probably encourage more of our clients to actually get these things updated and get the permitting process to make the resale values on their homes better. So that's something, again, just being aware if you've got clients with, listing with unpermitted structures, they may want to look now into that, and the process of getting those things permitted might be a little easier. We're in an age, and obviously, unless you have had your head in the sand for the last year or two, sexual harassment has been a big hot topic issue. And the number of people involved and the number of accusations are out there. And this is a slide provided actually by California Association of Realtors Legal Department, talking about some of the changes. And they say, the bar is lowered. In other words, the standards that are used to determine whether or not a charge of sexual harassment has validity has been lowered. In the past, you had to have had for somebody to accuse you of harassment and actually make a legal issue of it, there had to be a professional relationship in existence, maybe a signed buyer rep agreement or an active agency or an active contract. In the new law, it says basically if you hold yourself out as being able to provide professional service, that's all that's necessary. The accuser does not have to have any actual agency relationship with the person they're accusing. So, this could be somebody who shows up at an open house. It could be somebody who is at a meeting where you're talking about real estate. Very low standard there. It also used to be required that the accuser had to establish that they couldn't get out of that professional relationship easily. They couldn't simply walk away if the person was doing something offensive. That requirement has also been eliminated. So again, there doesn't have to be any actual established business relationship, and there's no requirement that the accuser establish that they couldn't get out of the relationship. And So just be cautious. Obviously, we want to encourage every one of our agents to be very cautious in this whole realm. Be careful of what you say, be careful of what you do, be careful of being in situations where you're more open to accusation. As an example, the office that I work in, I chose it because it's got large windows directly to the outside, and it's got large windows to the inside corridor, so that everything that I do, even if the door is closed and the sound is blocked, anybody could see what's going on in my office. That's just an extra precaution. And I want to encourage you to be cautious in those things, but also remember that it really doesn't matter all that much what your intention is or what your meaning is, and what you're saying and doing. What matters is how it's being received and how it's being perceived. So be careful with interpreted or received in a wrong way. I just want you to be aware the bar has been lowered. As professionals, we are more susceptible, and we want to be careful there. And again, if any of the other brokers want to step in and add to these comments, please go ahead and let me know on that. I'm not going to spend a lot of time. There's been several laws that have been passed on employment issues, and so I just wanted to point out for those of you who do have employees, or either one or more employees, the laws regarding discrimination, the laws regarding harassment, hiring practices, salary issues, obviously harassment and prevention training. There's even a new law regarding lactation accommodation that employers are going to be responsible for. So again, the CAR Legal website has a good Q&A on these laws. If you have employees, you want to double check and follow through on those things. Okay. Small change on home inspections. I don't know that it's going to have a major effect on us, but a new law in the realm of adding to water conservation measures. The new law authorizes home inspectors to include reports on the in-ground landscaping and irrigation systems. I don't know, most of the home inspection reports I've ever seen, specifically say they do not inspect the irrigation systems. This law authorizes them to inspect them, gives them some guidelines as to what types of information they want to, they would want to put down regarding those irrigation systems. My guess is it's going to be up to the individual home inspectors as to whether or not they're going to offer the service. And some may include it as part of their home inspection. Some may include it as an add-on to their home inspection. But you can pretty much count on all of them however they offer it, it's going to be at an extra cost to our buyers. When we're dealing with distressed property sales, we're looking at homeowners who are going through either facing a short sale, facing a foreclosure, or possibly undergoing a loan modification process. Back several years ago, a series of bills was passed called the Homeowner Bill of Rights, as a nickname to that. And it provided protections to these homeowners, set some specific guidelines regarding the timing of the notice, the amount of notice, the form of notice that they had to receive, the timing that they had. It put restrictions on lenders regarding how quickly they could foreclose. It put restrictions regarding dual tracking, where they were undergoing a foreclosure at the same time they were considering a short sale. So several of these things were enacted to try to stabilize the market and protect consumers. Pretty much all of those provisions expired at the beginning of 2018. And so it's been a little bit of a limbo for the last year. So this new set of laws pretty much puts back in place the entire set of Bill of Rights laws that were expiring at the beginning of 2018, and has made these permanent provisions. The thing that I want you to be aware of is that these only have to do with the responsibilities of the lenders and the relationship between the lenders and the homeowners. It doesn't have anything to do with the taxation issues. And I'm not real sure at this point whether or not the tax relief issues have been renewed or whether there's some expiring going on with those. So if you have clients that are facing a short sale or facing a foreclosure or a loan modification, be sure that you're advising them to talk to their accountants, talk to their attorneys, and get current advice regarding the legal and the financial ramifications of what they're doing. Some changes regarding homeowners insurance. We've gone through a couple of years of some very devastating wildfires up here in Northern California last year in the Santa Rosa area, this year in the Redding and Paradise area, down in Southern California in the Thousand Oaks, Malibu area. These have been devastating. We've seen more loss of homes, and up here in Northern California, even loss of life than we've seen in a long time. So the legislature, primarily in response to the Santa Rosa fires last year, so some of these really didn't get enacted in time to benefit those who were affected this year, but from here going out, several laws restricting insurance companies primarily and their ability to deny claims, to restrict claims, to cancel policies in areas that have had declared emergencies. And so, if you're dealing with any of these areas and clients who are dealing with some of these natural disasters, you want to encourage them to search out and do some research on what their rights are, especially if their insurance companies are putting restrictions on them. Now, obviously, the problem we're going to all face is that anytime we put restrictions on insurance companies and their ability to make a profit, they're going to get their profits some other way. And so I'm guessing that the long-term result on some of these laws are going to be a reduction in the number of insurance companies who are willing to write coverage in some of our more rural areas, especially our forested areas. And most likely over time, we're going to see rates increase because of some of these restrictions. But you want to be aware of it as well. And obviously, the caution for every one of you, anytime you've got clients entering into a purchase transaction, be sure they check their insurance issues at the very beginning. Find out that the home is able to be insured, get an idea of the cost of that insurance, what additional coverages might be necessary, and what the cost of those things are. Do not wait until 3 or 4 weeks into a transaction to investigate the insurance issues. Quite a number of laws were passed this year regarding landlord-tenant relationships. And again, our agents are not doing property management, so a lot of these issues are not going to be directly affecting your business. But you may be helping clients who are investors or in buying investment property or selling investment property. And so you want to make sure they're aware. One of the changes I'm pointing out right here is that on the notices, 3-day notices and 5-day notices, these statutory requirements for certain notices given to their tenants. In the past, it's always been calendar days. According by this new law now is going to limit those days to business days. So Saturdays, Sundays, legal holidays are not going to count as the days in these notices. So it's going to have to be, extend out the amount of time that landlords are going to have in providing some of these notices. And again, you want to encourage them to talk to property managers or talk to their real estate attorneys regarding their rights in these regards. Again, relating to the California wildfire situation, several laws were passed this year regarding housing, rental housing specifically, and trying to avoid price gouging, taking advantage of the situation when you have so many. Here in Northern California, in the Paradise area, over 14,000 homes were lost. And you've got thousands of people who have been displaced that are now looking, have had to try to seek other housing. And so several restrictions were put in place regarding housing, the timing on these emergencies, It doesn't just apply to the counties where emergencies have been declared, but any of the areas surrounding those counties that might be affected, where people might seek shelter, might seek housing. So it limits the amount that rents can be raised, and it puts restrictions on being able to evict tenants in order to be able to raise the rents on others. And it goes even beyond existing rental properties. And so if somebody has a home that suddenly they decide they're going to put it on the market as a rental, this law provides restrictions regarding how much they can charge for those rentals. So again, for your clients, especially your investor clients, you want to make sure that they're aware that there's laws protecting consumers in this regard. If you tuned in and have seen my video on the new forms, one of the changes that's been made to the residential income purchase agreement reflects this new law that requires professional inspections of decks, stairs, and balconies on residential buildings that have 3 or more units. So it doesn't apply to single-family homes. It does not apply to duplexes. But if you have anything that with 3 or more units involved, and they have any type of elevated structure, stairs, balconies, decks, there's a new inspection requirement. The inspections have to be initially completed before 2025, and then every 6 years after that. So again, a paragraph has been added to the residential income purchase agreement to describe this. And you may want to make that, if you are representing a buyer buying say a fourplex, you might want to make this inspection part of the negotiation to make sure that it's being done and that your buyer isn't inheriting that inspection responsibility. PACE liens. PACE is an acronym for Property Assessed Clean Energy. It's been in effect for several years. It's essentially a loan program that places a lien on the home through their tax bill. And it's become a major issue because as a tax lien, it gets super priority. And so pretty much universally, lenders are not going to lend money when there's an existing PACE loan on the books. The clients are being misled on these things. They're being told that the new buyer can assume these loans and pay it off over their tax bills. They're not only high interest and high expense, but the reality is nobody is going to assume a loan without either reducing the price of the home or having that loan paid off, as part of the transaction. So you want to be extra aware of these things. Over the last couple of years, the California legislature has done some laws to reform these loans and the loan practices to make them more protecting for the consumer. Some of the simple ones that came in this year, that the builder or the contractor cannot start work on the loan or on the improvement until the actual loan has been approved. And in the past, that hasn't been a restriction. And sometimes homeowners have gotten themselves into contracts with contractors that ultimately weren't approved as loans. The ability to repay. In the beginning, the PACE loans had no requirement regarding the client's ability to repay the loan. Up until this bill takes effect this year, their ability to repay could be established after they've signed the contracts and even started work. So this law says, no, you've got to establish that they have the ability to repay the loan before they sign the contract. And then finally, I want you to be aware that they've added, because PACE liens basically in the past have been available for energy improvements or water conservation. Now they're going to be also available for those who want to develop more wildfire safety improvements. So it might be something to use for landscape issues, may be used for changing of the types of siding or the type of roofing, for wildfire safety improvements. So what this is going to do is it's going to just provide another area where these loans are going to become advertised. They're going to be marketed to a wider group of people. And you may have yourself finding more issues and more situations where these loans are part of your transaction. So be aware of them. Make sure your clients are aware of them. And encourage your clients to look for alternatives if they're considering using one of these types of loans. There's some new laws regarding financial accountability for homeowners associations. And again, it doesn't directly affect you. It does affect your clients who are involved in homeowners associations. But I know for some of you, you may be involved as board members on a homeowner association, part of the board of directors. So these laws have to do with bonding, the bonding of the employees, the amount of bonds that they need to have, fiduciary bonds. It has some restrictions regarding how much a homeowners association manager can spend without specific board approval. And probably the biggest change is it now requires monthly review of the financials by the association boards rather than quarterly. So again, just tightening it up and trying to make the homeowners associations more financially accountable. One of the big things that affects us this year are the two bills that CAR actually sponsored. They call them the real estate cleanup laws. It changes some of the language of real estate. It changes some of the practice of real estate to conform to existing practice. It eliminates some of the laws that in the past were confusing. It and reaffirms, this is something that's important, the new laws reaffirm the independent contractor status for agents. And so I'm going to touch on these, and again, if you want a further discussion of this, you want to look at the new laws and new forms and revised forms video. So independent contractor status. In the past, the real estate regulations referred to employing brokers or brokers employing agents, and it gave the perception that there was an employer-employee relationship being established. And so to clean that up and to clarify that, some of the language has been changed. So there's no longer an employing broker. A broker is said to retain the services of an agent, not employing the agent. So things like that have changed. It establishes that the relationship between a broker and the agent may be either independent contractor or employee, depending on what their written agreement is. In the past, the term broker associate, although we've been using it for years, was never actually a defined term in real estate regulation. So broker associate is now part of the language of the real estate laws. And one of the nice things that I've just found out this last week is that the Department of Real Estate has also added the ability to register as a broker associate with your broker or change brokers as a broker associate through e-licensing. And up until just the last week or two, we always had to do that on paper. Now it is available through e-licensing, so that's a good one. The old law required that the broker hold the agent's original license and that we had to return that license when an agent left, or an agent had to cross out their broker's name and write in their new broker's name. In this day and age where you can print an original license every day of your life through e-licensing, that obviously was outdated, and that requirement has been eliminated. This is one that most of us have been violating real estate law for several years now, but there just wasn't any practical way to get around it, because the existing law said that when we're taking a listing, a copy of that listing had to be provided to the client at the time the signature is obtained. And those of you who've been in real estate long enough to remember the old, three-part forms that we used to fill out, where when we wrote out the listing at their kitchen table, we could leave them a signed copy of their listing. But in these days, with zip form and doing everything electronically, that was not practical. So the new law says that the copy of the listing has to be provided to your client as soon as practical after the listing is signed. And it specifically says that the delivery of that copy can be done electronically. So again, it just catches the law up to current practice and makes it so we're no longer violating the law every time we take a listing. Some of you, if you've written any business in the last couple of weeks, you've noticed the changes in the agency forms and in the agency confirmation. So these were some important changes of law. It changed a couple of things. It changed, first of all, some of the language of agency and tried to eliminate the confusion between agent and broker. Also, it eliminates language like listing agent and selling agent, and now refers them straightforward as buyer's agents and seller's agents. And instead of associate licensees, it refers to salespersons and broker associates. And so the language has been modernized, has been made more plain and understandable to our clients. Up here where it says third agency eliminated, all this simply means is that the seller is no longer going to be required to sign the agency form for the buyer's agent. So now under current law, the AD form is exactly the same for buyers and sellers. The seller will sign the AD form at the time they're signing their listing. A buyer will sign the AD form before they sign a purchase agreement, but it's no longer required that the agent then send that buyer's agency form over to the seller for an additional signature. Again, it's common sense. It's a disclosure of the potential agency relationships, and there's no reason to disclose those relationships more than once. The thing that is most important in the change in the agency law has to do with the restrictions placed on somebody acting as a dual agent. Remember, agency is always in the name of the brokerage. So dual agency, no matter how many individual agents are involved, if the same brokerage represents the buyer and the seller, it is a dual agency situation. And in the past, the agency form's only restriction on dual agency said that the listing agent couldn't disclose to the buyer or the buyer's agent that the seller was willing to accept less money on their property. And the buyer's agent couldn't disclose to the seller that the buyer was willing to pay more on the property. Right? That was common sense. Now, we've always interpreted that broader than that as to be careful regarding anything regarding the financial position. So that's now been spelled out so that the dual agent now is restricted from sharing with the other side their client's financial position, their client's motivations, their client's bargaining position, and any personal information of that client that might affect the ultimate price, selling price of that home. So very important that we follow these guidelines. I think these guidelines are actually something that we ought to be providing for all of our clients, whether or not we're in dual agency. I would like to see us get out of the practice of using terms like seller is motivated. Because frankly, when I see the term seller is motivated, what that tells me is, as an agent, I know this is overpriced, write me an offer anyway. And I think that's really a violation of our fiduciary duty to our sellers. So look at these guidelines on the new AD form and make this a practice that any of your client's personal information or financial information that might affect the price they're going to receive or pay on a home, be careful with those things. If you've written business in the last couple of weeks, you've seen that the confirmation section on the purchase agreement has been changed. The language has been changed to make it more clear. So listing agent now is a seller's agent. Selling agent is the buyer's agent. The word exclusively has been eliminated. The term dual agent has been added to make it clear what we're talking about. And now both the brokerage firm name and the individual agent's name is going to appear on the confirmation section, and the license number for each, the brokerage license number and the individual agent license number. Okay, and then it's going to be either they're representing the seller, they're representing the buyer, or they're representing both the buyer and the seller, which is the dual agency. Okay. Now again, be careful, and I've already had questions from agents on this. Adding the agent's name does not change the agency relationship. The agency relationship is always in the name of the brokerage. So if Allison James Estates and Homes is the listing agent, and an agent from Allison James Estates and Homes is also representing the buyer, the seller's brokerage firm is going to be marked here saying they're representing both the buyer and the seller. And what Zip Form will do is automatically check that box on all four lines. Because it doesn't matter how many individual agents are involved, if the brokerage represents both sides, everybody involved in this transaction is going to be in the role of dual agency. So if you're filling this out on zip form, you're not going to have a problem because you cannot check different boxes. But if you're, for some reason, you're filling one of these things out by hand, be careful that if dual agency is marked anywhere on the form, it's going to be marked everywhere on this one. So again, just a reminder, and if you are using zip form, if you're using the desktop version, be sure that you have updated your desktop version so that all the current forms have been there. If you are using templates, make sure that you've updated the forms in your template so that current forms are being used. Because every single listing agreement has been changed. Every purchase agreement has been changed. Every form that has to do with agency has been changed. Those are all updates, and if nothing else, the confirmation and the agency language has been changed on those things. The trust advisory has been changed in a very small way, but a very important way. And now it makes it very clear that the original trustees of a trust, that the owners of the property who placed their homes in a trust, are not exempt from full seller disclosure. The exemptions in the trust advisory only apply to a successor trustee who has not lived in the home. It does not apply to original trustees. That was the intent of the law all along, but the previous language was confusing in that regard. You're going to see a little bit of a language change on the signature pages on your natural hazard disclosure reports. And again, part of it is simply changing the language so that we're no longer going to have transferors and transferees. We're going to have sellers and buyers. And one of the clear things it's going to make is that the only agent who needs to sign the signature page is the seller's agent. In the past, it simply said agent and provided two places for it. And it wasn't clear whether both agents were supposed to sign or just one. So in the new language, only the seller's agent will be required to sign the NHD signature page. So that's kind of a wrap up of the things we're looking at coming into this new year. Let me give you a little bit of some source information. Yeah, and the legal Q&As on the CAR website, you can look at 2019 new laws, and you can look at the 2019 real estate cleanup law changes. And those give you a much more information, an expanded view, and I'll deal with some of the specific laws that might apply to your specific situations that I didn't cover. And some of the pretty visuals that I came, were from a legal webinar that was presented by Robert Bloom, an attorney with CAR. So if you just go to CAR.org, search legal Q&As, you can find those things. Also, if you want to look at the video that I did regarding the new and revised forms, you can simply go to youtube.com and then search for Stephen Rowe, new and revised forms, and you'll be able to pull up my video. It's about a 40-minute video on the new forms and changes that took place for those. So I appreciate it, and I'll turn this back over to Rebecca and open it up to any questions and any comments from our brokers.
No, Steve, I don't have any comments made. It's a good presentation. Thank you.
Steve, I think you've outlined everything extremely well. And obviously, these are very important changes coming into 2010. I think all of us have to just simply understand them and apply them as best as possible. And I think you've done an excellent job of doing that. Thank you so much for sharing this with us.
All right. Now, I just want to say that was a wonderful presentation, Steve, and we don't actually have any questions here right now. Brett K did say thank you. Now, again, any of our attendees, if you do have any questions, now is the chance to type them in now. You can also, if you have any questions regarding the new laws and regulations, just note that you can always contact your broker, your personal broker, whether that's Tom, Omar, Steve, or Michelle, or Jeff. Just feel free to always email them at their email or give them a call. Again, I want to say thank you everyone so much for joining us on California Brokers Business Accelerator. And thank you to our California brokers for all of your wonderful insight. As always, and a special thank you to Steve for putting together such a great topic and presentation. All right. Thank you again for joining, and I hope you all have a wonderful week. Bye, everyone.
Thank you, everybody. Happy New Year.